concept of doing this webinar is to allow people to learn from an attorney. I help people build their wealth in real estate. But as you know, Webb, I oftentimes sit at that closing table and I suggest to people that they protect their wealth. And they can do that through trust. They can do it through an LLC. There's different various ways. So you're going to be kind of bringing us from an attorney standpoint, what are some of the ways that they can protect themselves? So thank you for being willing to come on and share that insight.
Thank you for having me. Yeah, we're looking forward to it.
We are both local to the Charleston region, specific to Summerville, but we do travel all over. In fact, Webb and I often meet up down in Charleston for closings and to meet up with clients. And so we're the traveling team, so to speak, but we do cover all of the Tri-County area with real estate specific transactions and family planning. So, all right, Webb, well, I will let you go ahead and start screen sharing if you will.
Sure.
And then you can kind of introduce yourself and then jump right into it. We will have a time towards the latter part where if anybody has any questions, you can just drop them into the message box, and we will try to make sure we answer everybody's questions on the tail end of this. All right.
Thank you for having me. So my name is Webb Charpia. It looks like Charpia, but it's pronounced Sharpie. And my law partner is Roni Haskell, and we have a very complementary practice. I handle real estate, as Roni said. We work together on a lot of deals, and we do estate planning from simple wills and power of attorneys to trusts and all in between. And Roman is the courtroom guy. He does business law, injury related matters, and anything that your small business may need if they need to file a lawsuit or defend against one. So, but thanks for having us. Today's topic is estate planning, and in particular how that relates to some aspects of real estate. Let's jump in. So we've done the topic of 10 things that we think you should know. I did not select them in order of necessarily importance, but we'll go through them, and then as time allows, I have added a little bit of bonus content that we can discuss. But Roni, keep me on task if I look like I'm getting bogged down on something, because I do want to. I can be long-winded.
Yeah, I will.
The first item that I felt that was really important when it pertaining to estate planning was creating a team. When Roni and I met to discuss her goals, we started with a tax professional. We had some good guidance from those folks, because it does matter when you're thinking about doing estate planning. It's very important that we set up something that is tailor-made for your particular family needs. Not everybody does that, and then I want to make sure we're all coordinated with your folks, and it certainly takes a team approach to do good estate planning. We also recommend that the advice of a financial advisor. If you don't have one, it doesn't matter if you're just starting out or if you've got a large investments. It is important that you speak with somebody, because I often get asked tax related questions, and I have only a layman's knowledge of it. So we always defer to our professionals on those things. We also recommend a good banking relationship. If you're a new company, you're probably going to have to wait a couple of years to get lines of credit. I think they say 2 years is sort of 2 years of tax returns. But having a bank, I always ask folks when they're moving to this area, a lot of times they have big banks that they're used to working with, and I say, well, if you ever needed anything, who do you know at the big bank? And they inevitably tell me that they don't know anybody, and so I can usually make a warm introduction to these folks, if local individuals that can help them. We want to also this seems very simple, but I think it's often overlooked. You want to keep a list of individuals and their contact information when you do the estate planning. You cannot take for granted that the person that is assisting will necessarily know who your banker is, your financial advisor, your real estate agents, all the folks that if you had to downsize, in an estate situation, we'd want to know their contact information. So hopefully, Ronnie and I will be around a long time, but if I do estate planning for somebody and they live for a long time, it's important to keep a ongoing list of contact information. So the next topic I thought would be helpful when it talks about estate planning is sort of when do you form an LLC? If you're thinking about doing a project, I'd say I've characterized this into long-term investment versus rental. What are the pros and cons? Just briefly, if you're immediately turning something over, you may want to think about for a flip, for example. Most people assume that they want to put that property into an LLC for liability purposes, and they may be right. But one thing to consider, if you are turning that property over, you've got to get a tax certification from the Secretary of State. So the timing aspect of that should be, run that by my office so we can be aware of that if you do run into that. If you're doing a rental, I can't think of any reason not to have an LLC. You would want to have that barrier if something happened, so that you would not they would not go after your personal home. So an operating agreement, that's the next thing in that same tree. I've talked to countless number of folks that have had non-attorneys or even do-it-yourself. So they set up an LLC for their small business or for real estate, and they don't have anything in the form of an operating agreement. And that is like having a sailboat with no steering wheel, no way to control it. So it's absolutely vital that we get those things in place if you do have an LLC. If you have a trust, the nice thing about the operating agreement is you can name the transfer on death assignment, to your individual or family trust. So that's a nice feature too. If you're investing in real estate, so you would call Ronnie, get an idea of the market, figure out what a game plan is. Again, also talk to your other professionals and see where you can, where you're flexible. 1031 exchanges, I got a call about that this week. Had some folks that were interested in selling some property and they wanted to avoid capital gains, or at least defer it. You can't ever totally avoid the ultimate tax gain, but you can certainly defer it. They would identify and purchase another property using the funds from that sale to avoid capital gains. And then, as we mentioned earlier, the limiting personal liability. If you have an investment, it's in your name. Lord forbid something happened, a lawsuit attached to it, they could, and it was in your name. Anything you owned in your name, including your personal home, could be affected by that. So, again, talk to someone if you're thinking about creating an LLC and go from there. The importance of taking title, I thought it's often overlooked. Like I'll have folks, they've had the wherewithal to do deeds, the wherewithal to do last will and testaments. And you know what? Maybe they bought the house before they were married. Maybe they bought a house together, but they didn't use the survival ship language that you need to do to avoid probate. The terms joint tenants with rights of survivorship. When one spouse or partner dies, you don't have to typically go through probate. You You simply record a death certificate with the county. The county updates it in their record. No probate on that, and that's important. Also, you could potentially do a life estate, and that will touch and concern a topic that we have later on, but not to delve in that too deeply, but that is certainly an option, an attractive option for folks if they want to avoid probate, but also maintain the ability to live there. And then this is very important. So we've had, my law partners had to defend these suits before, or prosecute these type of suits, where we've had, usually it's a parent adding an adult child to their deed. That can create some problems if the adult child decides that they want to access their ownership interest and hire an attorney, which we've literally seen. It's very sad, but very common thing. It was done a lot, particularly during COVID. We would see folks, instead of doing estate planning, instead of calling and asking attorneys for their advice, were downloading deeds and finding ways to transfer or add children, with the intention that if something happened to them, that would go to the child, but not thinking about the ramifications of having a child sue them. It's as horrible as that sounds. It is unfortunately a reality.
Let me ask you real quick, Webb. So the probate, which I've been on the side of the real estate transaction many a times when the family is going through probate, and they'll wrap me into it, or an attorney will reach out to me to assist with a family that's going through probate for the sale of the property. But the reason, why is the reason that you would want to stay out of probate on a property? I mean, it's lengthy.
Well,
and expensive.
Yes. So those would be certainly two of the predominant factors. And then the time, the cost, I mean, the creditor period, we always say, the creditor period will end before a year's out, but we always say it takes at least a year to go through the probate process. And it is expensive. And if you're out of state, or if you have multiple heirs, it can be time consuming. It can be like a second job. So if you can avoid that, we would certainly recommend folks take those steps to not have to go through probate.
And the other thing is there's been times that I've had 3-4 siblings involved on a case where it was in probate, and if you give the rights of all siblings equal ownership in this thing, and you're putting them in business without having one PR of the estate, even if there is one PR of the estate, and you still have the siblings, they're all trying to keep each other happy without stepping on toes. Sure. A lot of emotions fly high during that time frame. And so it just complicates the whole transaction, while the property oftentimes is just sitting. And anytime you have a property sitting, it's for a length of time, 12, 18 months, that can become a challenge of a sale on the backside of it as well. So if we can keep properties out of probate, it's just an ideal win-win for everybody that's involved, including the equity that's in the property.
That's a great point. Some great points there. I identified this as a topic. People hear these, and usually it's in a negative or bad context, but you can do a living will. Some folks call it an advance directive. That just contemplates things. I mean, you really don't. You would need this if you were having major surgery. I know when my wife and I we have 2 beautiful children. They're it's crazy to think that they're 5 and 9 already, but I can remember when we were about to go to the hospital, we were able to send these to the hospital in advance, okay, and then cut down on the paperwork, because last thing you want to do when you're already stressed out about trying to get, hopefully a healthy delivery and everything else. More paperwork is certainly not something that I think people really want to deal with. So we can help you with that. And then, having a game plan. No one contemplates. We lost 2 friends this week that had battled cancer, and no one wants to contemplate that. And if you are terminally ill, a physician can ask your family, and this is presumably, in the context of you not being able to give your express wishes. This form would allow you to make a decision that you would make if you were able to give it. And I think it alleviates the burden that your family would have to make a decision that themselves, that they're not certain that their loved one would want to make. Or if you were in a bad accident. My wife went to school with somebody, and they were traveling and were in a terrible accident, and the family had to make a decision, to prolong their life or not. And, this form gives you an idea of those things. So, not the most awesome subject to talk about, but, having a living will is something that we include as part of our standard estate planning. So, last will and testament. Webb, if I do this, I'm going to die tomorrow. I mean, I've had people tell me that. No, you won't. I've had people tell me, these are the things I hear the most. That, oh, well, I don't have enough money to need a will. You do not have to be wealthy or fluent to need a will or want a will. Just like the advance directive, hopefully you won't, need it for quite some time, or you can go ahead and decide some important things. Roni and I have discussed this before. What happens if I, naming a guardian or somebody that can help you, or naming trustees, or who's going to watch over my kids? Lord forbid, my wife Louise and I are traveling. If something happens, who's going to have legal authority? Nothing can divest the family court's jurisdiction over minor children, but if they have a preference in writing through a legal document stating the person's wishes, certainly that is something that will, I would imagine would go a long way in that determining factors. But I get this a lot too. Well, I'm not old enough to have a will. What age do you have to be to need a will? I was giving a presentation one time, and I had someone, and this was quite a few years ago, and they said, "Webb, do you have a will?" And I, honest to a fault, said, "No, I do not." But here I am giving a talk on wills, so that was something that my wife and I immediately got taken care of. So when is it time to think about a will? I think there's a couple of things. Buying a house. Ronnie's introduced you, her team's introduced you to buying a house, and you now own something. Okay, be a good time to get a will. Getting married, getting divorced. I mean, if you look at your will, you had your will done a few years ago, and the staple at the top starts turning rusty. Might be time to get that thing looked at. There are probably some changes. Your children may be adults if you have them. And you may have set up guardian language for them that's not necessary. You may have people in there. You may have an ex-partner or spouse named as your beneficiary. I mean, so the time to look at your will is today. Okay, and if you don't have a will in South Carolina, you most likely, it depends on ultimately your assets and what you got. But most people, that own a home would be going through probate. It's costly. If you have minor children and you die without a will, there's a chance that your minor children can get half of your assets, even half of your home. Okay. I mean, that's a sobering subject to think about. Okay. Trusts. I get this a lot. People will say, "Hey, my neighbor's got a trust, so I think I need one." They're not fashionable items to have. You don't have to be in vogue to get these. They're not, we can do a simple trust. And if you do it right, there's a little bit of homework assignments for you. I can't, set up a trust for you and guarantee that, your car's titled, in the right way, or that, you've added someone to a bank account, so we do have a little bit of homework when somebody gets a trust established to make sure we avoid probate. But generally, if you follow those things, you can stay out of probate. So it's attractive for somebody that, and I often get people that have lost a family member. They've gone through the probate process, and they say, I want to avoid that. And how do we do it? So that's when we recommend trusts. So we would recommend establishing a revocable living trust. I get requests to set up irrevocable trusts. I've never done that. Wouldn't recommend doing it. Banks don't like them if you try to do business with them. Irrevocable. So we set up revocable living trusts, and we usually recommend placing your primary residence into that trust. That's where a lot of times people end up, having to go through probate. As Roni knows, through the real estate process, if husband and wife or partners or whomever's on title, if party A dies, fine, we record the death certificate, joint tenants' rights to survivorship. Well, when party B dies, there's no way to deed that property. There's no one legally able to deed that property out, so we have to go through that probate process, get a personal representative. It's not executor like it is in most states or John Grisham novels, but it's called the personal representative here. They have to get appointed, go through the probate process. Hopefully, there's permissions in the will that allow them to list the home or sell the home, but placing that property into a trust, we can avoid probate that way. A lot of times your spouse or partner will be either your co-trustee or your backup. I think it's vitally important to have redundancies in place. I typically recommend you pick a healthy person and somebody that's not too much older than you. I say, parents are great, but if you age everything up a little bit, are those people going to be ready, willing, and able to assist you? Siblings, close friends, folks that are around your same age and in good health, those would be people we would recommend, and certainly have the conversation with them about it.
And the nice thing is, and I'll just bring up, Webb, when you and I first sat down developing my trust, it's a humbling situation when you ask the pointed questions of who would you like to entrust to do this, to be your trustee. It really is a humbling experience to go through that, because it starts, your mindset of these later years and planning perhaps, but it is. And it's a conversation that you've got to have with those trustees to make sure that they're willing to do that as well. But again, I just want to reiterate the idea of having a trust, especially as we are working with so many people that are building wealth in real estate. It is imperative that they build out their will and they cover themselves with a trust in addition to that, to help give a level of protection and appointees when the time does come.
Yeah, very well put there. The reason you do want to talk to somebody, it sounds so obvious when you're discussing, but that person doesn't have to be your trustee. Like if you name them in your trust as a successor and they say, nope, that's not for me, and you've not consulted with them, you most likely then have to go through a court process that you and the very reason you set up the trust was to not have to go to court. So,
Mhm.
but that's the reality. And, fortunately here we have, Dorchester, Berkeley, Charleston, their area, the Low Country, Tri-County area, we have very, very good courts and good judges and good personnel. But and no offense to them, but if we can keep people out of court, that's good for everybody. So that's why we do trust.
That's the goal.
That's the goal, right? So healthcare power of attorney. In South Carolina, you can name an individual to serve as your healthcare power of attorney. This individual, they can make important medical decisions for you. They can obtain medical information on your behalf. We get calls about this all the time. So this is a great call. Okay, I'll get a call from somebody and they'll say, "Hey, I want to obtain power of attorney over my insert whatever here, friend, family, whatever." And I said, "Well, can they not call me?" And they'll say, "What do you mean?" And I said, "Well, put that on the shoe on the other foot. What if I called and said I was your best friend, and I was able to obtain your power of attorney without talking to you from a law office, and then I could make any decisions on your behalf that I wanted to concerning medical, and we'll get into this in a minute, financial stuff." So no, you need to have that person contact me. We'll have a conversation, and if they're able, come in my office. We'll have them set up and with a healthcare power of attorney. So I did want to note it's important when considering that to select someone you trust. As I talked about earlier, they'll have access to vital information that it could include your Social Security and other things that, quite frankly, you may not want to have access to or give them access to. So think about that when you're having that discussion, as we alluded to earlier. If you're a lot of times people's power of attorneys are the same people that are their personal representatives or trustees or backup trustees. So at any rate, it's a good item to have. So the durable power of attorney, believe it or not, you will only get to use your last will and testament one time. Okay, there's value there certainly, but in terms of times that you can use it, you get to use it one time, and that's it. So, but your durable power of attorney, that's a forever item. Okay, and it's similar to a healthcare power of attorney. You can name somebody in advance, before you have any illnesses or issues, that can assist you as your fiduciary. We get this call a lot. We're at closing. Ronnie's helped somebody in a new home, or they're selling a new home. Where are you moving to? I always ask people that. Where are you going? I'm going back here for see my grandkids. I'm moving here. We've downsized. We're upsized. Whatever we're doing. Okay. Do you have a power of attorney? Sometimes they do. Sometimes they don't. But at least in South Carolina, if you move to a new county, you need to get that power of attorney recorded in the new county that you reside in, because you're in South Carolina. You have to record a durable power of attorney. Okay, and that protects you. It protects third parties, and it's a legal requirement. Your power of attorney will give you nearly unrestricted access and control over banking. They can sell a house. They can make plans for you, financial decisions. So it just like the healthcare power of attorney, it's important that you select somebody that you trust with that information. Okay, and unless that power is revoked, they can mostly do. I'd like to think that most people who are serving as power of attorney would do good things, but sometimes I see the ugly side of things in my practice, and we'll have somebody that takes advantage of that position, and just make sure that that's somebody that you trust implicitly to help you.
And I'll bring up to light too, with closings, sometimes we do have a power of attorney that has to step in for a transaction. Make sure that the power of attorney is updated. I mean, the reality is friendships can falter, even families, relationships can falter. So if you've got someone, or maybe the power of attorney you had appointed has deceased ahead of you, you've got to keep these updated. It's pretty simple to do. You just got to have that relationship with an attorney to be able to initiate the new request. They'll push it through and record it. It's not a big fee to set this up and establish it, and then renew it as needed.
Good
right?
point. Very good point. So we have certainly over the years had people that needed updates, and we can update them. We've had people that we prepare these for, at the time they come in for their estate planning, we include that in our standard estates package, a durable power of attorney. And when you're buying and selling real estate, there's a provision that we have in our form that says this person can make these decisions concerning the buying and selling of real estate, investing, whatever they need to do on behalf of that person that they're serving as their power of attorney. We mentioned this earlier, that they be recorded. I can immediately spot a do-it-yourself power of attorney. I'm a big fan of estate planning, but there's a reason why estate lawyers exist, and there's a reason why other professionals exist. If you do not know what you're doing, you can inadvertently create something that may not help you. I won't work with a power of attorney that is not been prepared, recorded properly. We review these to make sure that they've been executed and hopefully, done correctly. If you miss a signature or a witness or some form of notary act, you might have a document that is, I had this years ago, had somebody that was, went to their local church, or they had a wills clinic. They were done with the greatest of intentions, and unfortunately they were missing signatures and things. So we can't rely on those if they're not validly executed. So talk to an attorney and get those set up. Okay. Number one call we get, Ronnie, we've just moved from here, so we've got to start over, right? And sometimes there are good reasons not to have to start over. So, when Ronnie and I were kind of brainstorming ideas and figuring out things, it's never a bad idea to get your stuff looked at. We'll review anything that you have for free. I don't want to, have somebody sit by idly because they're too afraid to go talk to me because they think that I'm so expensive that I will review your estate planning, and a lot of times you probably find. I mean, I did note in here, South Carolina will generally honor a validly executed out-of-state will, and when I say validly executed, I can't certify that the will you had done in whatever state that you're in is valid, but we can call somebody who's licensed in that state, present the will or whatever legal document that's been created, and find out, and hopefully you'll be fine. South Carolina has reciprocity with out-of-state wills. So now, if you're thinking about moving to South Carolina, I would not recommend you go in and do comprehensive estate planning, right before you move your home state. I mean, you may end up creating legal documents that are state specific. And why would you want to bear the cost and headache of that and then have to redo it again? Not to say that having a game plan is a bad idea, but I've seen that all too common, that people will go in and get everything set up and then move, within 6 to 8 months, a year. And so just as long as there's no significant health concerns or anything, you may want to contact the attorney at the state you're moving to and get something going in contemplation of that move. And then, I put all this is tongue in cheek, but my neighbor insists that they got all their stuff done. So Webb, you're wrong, right? So, and listen, I certainly can be wrong on some things, but except in novels by John Grisham, somebody doesn't write their last will and testament on their deathbed and have a whole drawn out deal over a will. And along that vein, that's called a holographic will. And in South Carolina, if you do write your own will and sign it and don't have it notarized or witnessed, that's not a valid will in South Carolina. Okay. And unfortunately, you wouldn't know that until the loved one went to go try and handle your affairs. And, you're right back in the same situation that you would be if you didn't have a will. Now, what does need to be updated? We've talked about this earlier. We had some folks, they move into the area. A lot of times their power of attorneys are state specific. So we would recommend updating those power of attorneys to get those done to contemplate South Carolina law. Because number one goal is we want you to be protected. So if you're not protected, that's a concern for us. Okay. And then if you're, let's see, what's my note say here on this? So out of state will, we get this a lot. Somebody's wanting to, their financial concern is they've had this will done in whatever state, and Webb, I just need to make one or two changes to it. I will not do a change, which they call a codicil, to somebody else's legal work that was prepared in a jurisdiction that I'm not licensed in, because you're asking me to vouch for all of this stuff being true and correct and prepared properly, but you want me to do this update for you. Now, certainly sometimes there are exceptions to this, but if somebody has a will prepared by another South Carolina attorney, that would be an exception to that. Okay, so all right.
All right.
Go ahead, Ron.
I think there's always going to be questions and more that we can share in regards to this topic. I think you've done a fantastic job, Webb, of kind of laying out. So these are some of the things that I made note of that I think it summarizes being proactive versus being reactive to a situation, planning for the future of what we inevitably know, there will be end of life, and protecting your investment. Even with my own personal residence, I see every single purchase as an investment, because quite frankly, there's a lot of money that's wrapped up into each property that I own, and as is everybody. So protecting the investment, build a relationship. I call it pool of professionals. You are close to mine. Not only have you helped, protect my own assets, but you also have helped. You've been instrumental with a lot of my clients, bankers, CPA, financial advisors, building those relationships and having them noted so that you can share it with your loved ones, have it all in one place, one safe place, so that if something does happen to us, that person, if they sign on to be the point person when the challenge does happen, it makes their job so much easier if you're organized and have things accessible to them. And so you've done a great job of presenting all of that to us, Webb. I appreciate it so much. Anything else kind of last minute that you want to add?
Thank you, Roni. And I appreciate the praise, but it takes two to tango. You have to have somebody that's able to get the information to you, organize it in a way that's beneficial and easy for me to understand, and then get it executed. So we appreciate all the help that you've done with us over the years. I did have this, and I quickly will go through this because I always include these little tidbits in here. no amount of estate planning will keep you out of probate if you do not update your accounts. Okay, so why do we have a banking relationship? Why do we have a financial advisor relationship? Why do we have, a CPA? Because those people can assist you once we've done the estate planning to make sure that you've got everything that's congruent with the estate planning for all those different facets. And same thing with retirement accounts and all of those things. I've seen people have to go through probate before, in spite of good estate planning, just because they did not update something as simple as the beneficiary on a retirement account. Now, I don't know many investors that aren't asked that, or but we have seen it. So just that's important. Everything we talked about today, if you leave my office and you have these documents and you put them somewhere securely, but you don't get anything updated, then we may have done a lot of good for you, but this helps us button up that last step. So Roni and everyone, thank you for letting me run my mouth a little bit about a topic I'm very passionate about. And thank you for your time as well.
Yeah, absolutely. It makes me rethink, because I when I started working at the ripe old age of 21, I established a 401k. I've got older IRA. It makes me wonder who I put down as my beneficiary back in the day, and maybe I need to revisit that, So it's just putting the things in place and then revisiting it every so many years to make sure that it's updated. But Webb, you've done a fantastic job. I think we've got one more slide on here that shows our contact information. If you'll put that up there, they can reach either one of us with any questions. If they need assistance with buying and selling or investing, of course, my team would be honored to help. If they need someone helping them secure their assets or close out a property, you and your team do an amazing job of that. So we welcome anyone to reach out to us to make an appointment and have further conversation. But thanks again, Webb, for joining. And for me, I'm Roni Haskell here at Keller Williams, and let us know if we can ever be a benefit. Thanks again.
Thank
Bye,
you.
guys.
Bye.